This program is brought to you by Emory University.
I am Tim Terrell. I'm on the faculty here at the law school. I am a last-minute replacement, and you'll see why in a moment, to help to moderate this panel, and I welcome you all to this discussion, which I think is going to be fascinating. With any luck, this panel will very much touch on and elaborate on the themes of inequality and accountability that we just heard from Judge Kaczynski. Let me quickly introduce the panel, and then what I want to do is to introduce the topic in my own way. In the order of the presentations that we will hear, I'm going to start with Professor Richard Freer. As he famously emphasizes, he is the product of a state law school, graduated from UCLA. He nevertheless managed to clerk for a federal judge, which is surprising. He is nevertheless one of the great scholars of this law school. He is the author and co-author of 11 books. He is also the quintessential fabulous teacher. He has won not only the teaching awards here at the law school numerous times, he has also been the recipient of the university's teaching award. So he is both a scholar and a wonderful speaker, as you'll certainly learn if you have not had a chance to interact with him as a faculty member here. He is, of course, going to be speaking because he is self-interested in all of this. He is concerned about the fact that his courses in civil procedure are largely becoming irrelevant as the federal courts disappear, and he is going to be talking about that abandonment of the federal courts and should we care about any of that phenomenon. Secondly, we'll hear from Colleen Muawad, who is a partner at the obscure law firm of King & Spalding. She is with their international arbitration group. She has conducted arbitrations quite literally around the globe in both public and private kinds of international matters. She has in oil and gas, communications, you name the area, she's done it. Her JD happens to be from Harvard. She's going to be speaking on the ways in which, despite the fact that ADR is out there and very powerful, she'll be talking about the ways in which courts are still particularly important to ADR, but the whole thing has now been reversed, as far as I can tell from her paper. What's important is ADR, and courts are simply there to facilitate ADR, and as opposed to what would be traditionally the other way around. We'll also then hear from, Professor Francis McGovern from Duke Law School. His JD, sadly, is also from a state school, the University of Virginia. He has cleaned that up, however, having been an ex-Marine. He has taught at numerous law schools as a visitor. He's currently at Duke, of course. He is a frequent speaker on ADR issues. He has taught in that area for a long time, of course, and is much published with regard to ADR issues, and he has worked with countless organizations, including the United Nations, to set up arbitration schemes around the world. And his issue that he's going to be focusing is the way in which ADR can continue to bury the federal courts, a mechanism for resolving disputes by improving the communication within ADR, and that is the specific function of presentations of evidence and arguments in a multimedia form, and he'll be actually demonstrating that for us during his presentation. Now, to set up the nature of this panel, what I wanted to do is to open with these quick remarks, and I'll just do this quickly and allow the panelists to then take over. Simply speaking, it is this. I want you to imagine that you are watching a professional football game, as indeed many of you might have been doing recently. You're watching a particularly bruising running play with lots of agitated manhood crashing together in the middle of the field. As the play seems to be ending, two players from the opposing teams begin to yell and gesticulate at each other, and the referees run in to separate the players and settle everyone down. No penalty flags are thrown. The players plead their grievances to the refs, and the team's coaches are yelling loudly from the sidelines. The refs push the players and coaches away and huddle among themselves. The refs disperse, but one among them moves the ball 15 yards in favor of one of the teams. Fans in the stadium and you at home are apoplectic. What just happened? What infraction occurred? Why was it resolved in the fashion it was? Your worst fear is that what actually happened was a payoff, that one of the teams bribed the refs into the result, or that some secret deal had been struck. Perhaps the teams agreed between themselves with the refs' involvement that this penalty would be imposed now, but the other team would henceforth get more favorable treatment for the remainder of the quarter. Or maybe the refs simply like one team more than the other. No one knows how the situation and decision on the field have any relevance for behavior in the future in any games. The question is then this: were you actually watching a game of football or something else? When did the game perhaps stop being what you would call football and instead something closer to, and I would quote something like this, chaotic athleticism with an oblong ball? Is there perhaps some difference between professional football and playground football? To put this issue in operational terms, are the refs simply dispute resolvers among the players so that no one else is relevant to this conversation, or are they more integral to the game itself, perhaps as important as the players themselves? If these issues seem relevant to you, then welcome to the world of alternative dispute resolution, primarily mediation and arbitration, where disputes are decided in secret, no precedents are established, and no one outside the private context of the disputants can praise or criticize the result. It is hermetically sealed justice, done ironically in the name of a better achieving fairness. It is this world that our speakers on this panel will develop for us in interesting detail in different contexts. But to move to our first speaker, let's add some new and disturbing detail. Let's say the NFL hears the complaints from fans who are becoming frustrated and dissatisfied with their viewing experiences and offers to these outsiders the opportunity to learn more about what is actually being observed and decided on the field. But to get this extra service, the NFL, rather than telecasting the games for free to viewers, requires fans to pay an extra premium, much like pay-per-view broadcasts. The NFL calls this extra payment a tax. But viewers balk at paying this tax like any other, and so they come to terms with the mysterious dispute process on the field, dissatisfying though it may be. This, I would argue, is the situation of the federal courts as they try to understand their position within the overall universe of dispute resolution. Courts are a system that all of us, not just the disputants, finance with our tax dollars. And federal courts have been seeing fewer and fewer of those dollars over the years. Maybe the courts just aren't worth the pay-per-view cost being imposed on all of us. Let's let the individuals who are having the dispute pay for the resolution themselves. Why should we pay extra for something that involves them and not us? Or does the dispute between the parties actually involve us, others, outsiders as well? With that, we turned to Professor Freer.
Thank you, Tim. It's a great privilege to be on this panel, and I want to add my thanks to the Thrower family. I've been on this faculty 30 years, and over all that time, the Thrower Symposium has been a hallmark of the intellectual life here, so thank you. And again, it's a privilege to be with you. Now, let's say I have a dispute with somebody, and if my adversary and I are willing to pay for it, we can opt out of that public system of court litigation with its judges and its juries, and we can submit to arbitration or mediation, or in California, as the judge said, even to a private trial. With arbitration, we would hire a third party to hear the evidence and declare a winner. With mediation, we would hire a third party to help us settle our differences. Now, about 30 years ago, these forms of private ordering emerged under the rubric Alternative Dispute Resolution, or ADR. They are now so mainstream and so common that many people consider them the full equivalent of court litigation. I want to discuss two arguments that urge caution concerning privatization. Broad criticism that's been around for 30 years at least. And the second one is narrower, and it is raised about some recent Supreme Court cases. Now, as to the first, critics say that equating arbitration, mediation, and court litigation is myopic and maybe even dangerous. Oh, sure, it's true that if all we want to do is resolve a dispute, make it go away in an orderly way, these are all fungible, they all get the job done. But court litigation is not just about that. It serves broader societal goals. Primarily, it generates law. Most of the law that governs our daily lives, the law of contract and torts and property, it's case law. So along with legislatures, courts, by deciding cases, play a fundamental role in our social ordering. Now, of course, not all cases make precedential law, that's true, but they apply the law in a public, transparent process. And this not only engages the public and educates the public, but it also encourages acceptance. The courthouse is a public building. The hearings and much of the evidence are available to the public. The judge's reasoning is available to the public. And of course, the use of a jury also reflects a commitment to democratic involvement. In the privatized world, we get none of that. There is no public access. There's no explication or development of the law. So critics have argued for over 30 years that taking the cases out of the court system reduces the judiciary's opportunity to discharge this public law-giving function. So they've argued this for 30 years. Were they right? Has it turned out that some exodus to private resolution has thwarted the courts in their missions? Well, something has, because in the interim, something profound has happened to the court model. It has morphed. What we have seen over the last generation is not just some exodus from court litigation, from that model. We've also seen a significant transformation of that model. And the cause, it seems to me, was docket pressure, which built over the last third of the 20th century. And some of the causes are obvious. Over that period, we recognized more enforceable legal rights than we had before. And we had a commitment to enforcing those rights through civil litigation. And of course, we have an exploding criminal docket, which pushes the civil cases to the back burner. And notwithstanding all of this case pressure, the Congress steadfastly has refused to increase the number of Article III federal judgeships. So with more cases, but no more judges, something has to give. And part of the give is an exodus to privatization. And that's not the only exodus. Let's not forget that the Congress has taken through the decades a lot of cases out of the Article III federal courts and sent them to administrative agency for adjudication there. But even after we funnel all these cases out of the federal courts, the caseload burden persisted, and it led to a change in the role of the judge, and it changed the character of court litigation. For one thing, judges had to delegate more. So you have staff attorneys and more law clerks and magistrates and the like, and it has become an enormous bureaucracy. I think these numbers are amazing. There are 965 Article III judgeships, 965 places, slots for federal judges. And yet, the federal court system employs more than 30,000 people. So the 3% of the workforce in the federal court system. We also saw the rise of managerial judging. Judges took charge of case management, actively pushing toward resolution, and resolution increasingly meant settlement. Now, most cases have always settled, that's true, but it's usually after the lawyers have litigated for a while, they get a sense of the value. They've done it without pressure from the court. That has changed dramatically. The original federal rules back in 1938 did not even contain the word settle or settlement. Now, the rules are seriously about settlement, and they push settlement really from day one. It's on the agenda, and it's a court goal. And this goal of settlement is so deeply ingrained that we now actually have judges who will say that if a case goes to trial, it means the system failed. So, not surprisingly, fewer than 2% of cases filed will actually go to trial. So we've changed our theme song in court litigation. I always thought a great theme song for court litigation was Pat Benatar, "Hit Me With Your Best Shot." But that's not it. Now it's all about the Beatles' "We Can Work It Out." And I love that song. Think about the lyrics sometime, because it's a universal truth. We can work it out if what? We can work it out if you see it my way. That's how we can work it out. So we lose the public function. Settlements are not public. Settlements are private. There is no hearing. There's no written opinion. Even the law-giving function is in question. On cases that they decide, the U.S. Courts of Appeals now, 70% of their opinions at least are issued as non-published or subject to a non-citation rule, and that means that even the judges do not consider them to be precedent. That is not a system that is aimed at public adjudication and law giving. So the line between what we got on the public side, what we got on the private side, is not what it used to be. What we are opting out of today on the public side looks a whole lot like mediation. Now, let's shift to the second argument I want to make, the second point. In recent years, the Supreme Court has been very, very supportive of arbitration. The Federal Arbitration Act was passed back in 1925, and at that time, courts were hostile to arbitration. A lot of courts would not enforce arbitration clauses at all. The Arbitration Act, the FAA, rejects that hostility. It requires courts to enforce arbitration provisions. But let's think about the context. In 1925, and really for 7 decades after that, what we were talking about were arbitration agreements found in commercial contracts between businesses. That has all changed now. It's a radically different world now, because now they are ubiquitous in consumer contracts and in employment contracts. These are often called contracts of adhesion, not because they're fraudulent, but because they are on a take-it-or-leave-it basis. And everyone in this room is subject to an arbitration provision in various adhesion contracts with your cell phone provider, your credit card company, your stockbroker, all of them. You have waived the right to sue, and you have agreed to arbitrate any dispute. And you had no say in the matter. It was simply part of the deal. You want the cell phone, you sign up. So the adhesion contract is a radically different context from the one that was addressed by Congress back in 1925. Instead of dealing with the allocation of money between businesses, arbitration today routinely implicates individual rights, rights of consumers, rights of employees. And of course, as we said, arbitration provisions are not bargained for, they are imposed. Nonetheless, despite the different context, the Supreme Court has quite reflexively applied the FAA, the Arbitration Act, to contracts of adhesion. So we're all subject to these. Now, let's take another step. When you go home today, go look at one of those contracts of adhesion that you're subject to. You'll see an arbitration clause, and you'll probably see something else. You will see a class action waiver. And that means if you're going to arbitrate, you must do it alone. You cannot join with other consumers. Now, why would the company do that? Well, that brings us to a case called Concepcion, which is a 2011 Supreme Court decision. There we had 1 million or so customers sign up for a cell phone plan in California. And under the plan, they were to get a free phone. They all got their phones. But then the company charged them for the sales tax on the phone, and this worked out to about $30 per person. Arguably, billing the tax on a free item violated the California consumer protection laws. But the claim, if there is one, is for $30. Now, realistically, most people are not going to do anything. They're not going to file an arbitration over $30. It's just not worth the effort. But they might file if they could join together. If they could have a class, then maybe they would. I guarantee you they would find it easier to find a lawyer, because what was a $30 case may have become a $30 million case. But remember, the contract forbids group claims. So by combining the arbitration clause with a class waiver, in small claims cases at least, the company effectively avoids being brought to account. So California law said, based on this argument, we will require the company to go to arbitration in a class context. Even though the contract said, no, you're going to do it because otherwise our consumer protection law simply will be unvindicated. Now, obviously, we have some reactions to this. We're nervous about the motivation of this case. It's not really about consumer protection as it may be, as much as it may be generating fees for the class lawyer. And we might also respond by saying, look, California, if this was that important to you, maybe you should have criminalized the behavior or gone after them administratively. But on the other hand, shouldn't the state have the authority to make that decision on how to enforce its own law? And in Concepcion, the court said no. It's all about the contract. If the contract said no class arbitration, then there is no class arbitration. So even in a contract of adhesion, and that overrides the California idea that we think it's important that you have access to the class procedure. Now, 3 weeks from yesterday, the Supreme Court will hear argument on a case on whether federal law may allow class arbitration, even in the face of a contract that says no, when individual claims simply would not be pursued as a factual matter. So we'll see about that. But the interesting thing about Concepcion to me is it's state law. And to me, the reflexive wholesale application of the Arbitration Act to all contracts, even contracts of adhesion, raises a significant federalism issue. This goes beyond saying to a party, you agreed to this, you got to do it. Here, we're telling a state that we're rejecting its policy decision about how to enforce and vindicate its law. So many states, for example, have laws that say certain kinds of claims cannot go to arbitration. Public interest claims and the like. They have to go to the courts. Doesn't a state have the right to say that certain kinds of claims that we create are important enough to demand the attention of the government system for dispute resolution, and important enough to demand public proceedings rather than behind closed doors? Under Concepcion, no, the state does not have that right. An arbitration agreement covering such a claim would preempt the state law. So as we said at the outset, we've long known that we can opt out of court litigation and into private ordering, but now I think we know a couple of other things. First, that what we're opting out of looks a whole lot like something we might be opting into. And secondly, and very troublesome to me, it appears that in some cases the strong party to an adhesion contract may effectively be able to supplant a state's authority to decide how to enforce its law. Thank you.
I feel like I've come to defend my practice on today's panel. I'd like to also echo Professor Fear's thanks to the Emory Law Journal, to the organizers, to the Thrower family for having us here today. I'm quite honored and looking forward to hearing from our other panels today. I'd like to start my remarks by picking up on the theme that Professor Freer just addressed in terms of the exodus of the parties away from the courts and into arbitration, and specifically by starting by looking at what makes arbitration attractive to parties. And there were some comments earlier this morning about the economics of it and whether or not arbitration actually might exclude some parties who may not be able to afford going to arbitration, and whether that was really fair and giving parties access to justice. In the context of international arbitration, which is the one with which I'm the most familiar, there's actually no real other option than arbitration, because arbitration is what offers a neutral forum. And neither party wants to give the other party the home court advantage. And so arbitration is really attractive for that reason, in terms of providing that neutral forum, and also allowing the parties to choose their decision makers, to choose the procedural rules that will apply to their dispute, the applicable law, to choose the seat of the arbitration, the legal seat, which has implications that I will discuss in a bit, the language of the arbitration. All of those things are within the parties' control, and they're really able to create a custom design dispute resolution system. But notwithstanding that, the question is how private is, or how privatized actually is international arbitration. And many commentators, and Professor Terrell alluded to this in his introductory remarks, that many commentators have argued that the arbitration couldn't exist without the courts. The courts are necessary to allow arbitration to thrive as a system, and that they're there because the arbitrators actually lack the coercive powers that the courts have. They're not able to force third parties to come and give evidence. They can't enforce their own awards. They need the courts to do that. So because arbitrators don't have that coercive powers, the courts are actually necessary in order to allow that system to continue and to thrive. So there may be an exodus of the parties out of the courts into arbitration, but I would posit that exodus isn't complete and it hasn't severed the ties with the domestic and national courts. in fact, there continues to be a very important judicial component to international arbitration, and this happens at various moments in the life of an arbitration where the courts have a role to play. So could arbitration ever fully sever its ties with the national courts without undermining its effectiveness? There's one system, which is the system of the World Bank's International Center for Settlement of Investment Disputes, which I'll refer to as ICSID, that stands as an example of as private a dispute resolution system as there exists today. And although it's a specialized institution that only handles investment disputes involving a private party and a state, it's created basically a self-contained, delocalized dispute resolution system that entirely excludes the courts from the process, and they're save for a few exceptions. But it's really sort of created this, encapsulated a dispute resolution system and try to shield it from what's going on from national courts' involvement. And so my presentation will come in two parts. The first, I'd like to sort of quickly survey some of the areas where we traditionally see the courts play an important role in the life of an international arbitration. And then second, I'd like to focus on the ICSID system and what some of the key features that have made it able to insulate itself from the judicial involvement. So first, if we take a look at the ways in which the courts have an opportunity to support or meddle with, depending on your perspective, an international arbitration in its life. If you look at it, let's start at the beginning of an arbitration. And here I'd like to look at the tribunal's jurisdiction. Under most international arbitration rules, arbitrators are empowered to decide their own jurisdiction. It's the principle of competence. But if one party commences an arbitration, the other party may turn to national courts to enjoin the arbitration and ask those courts to make a threshold determination as to whether an arbitration agreement exists, and if so, which parties are bound by that agreement and thus forced to go to arbitration. Now, these are questions that clearly relate to the tribunal's jurisdiction, but a court may be called to answer that question first, and in some jurisdictions, the court is the one that has the last word on that determination. In the course of an arbitration, there are also several instances where a party may call upon the courts to intervene. And one that is near and dear to my heart is the time of challenging an arbitrator. And a lot of the arbitration rules in the leading institutions, for example, the International Chamber of Commerce or the London Court of International Arbitration, the LCIA, provide a mechanism for the parties to challenge an arbitrator's independence or impartiality. But notwithstanding that sort of internal mechanism by which you might challenge an arbitrator, the law of the seat where the arbitration is held might still afford a party the right to go to the courts. So for example, I had a case where it was an LCIA arbitration in front of the London Court of International Arbitration. The seat of the arbitration was London, and the other party challenged 2 of the 3 arbitrators. And under the LCIA rules, what happens is the LCIA court designates a division of 3 members who are formed specifically to hear the challenge. So we had rounds of briefing, we had a hearing, and ultimately this division rejected the challenge to the 2 arbitrators. Notwithstanding that rejection, the English Arbitration Act, because the arbitration was seated in London, applied, and under the English Arbitration Act, a party, after the institution has resolved the challenge, a party still may go to the courts and ask them to review and to address the challenge in question, which is what happened here, and the other side filed a Section 24 challenge to the 2 arbitrators. Ultimately, they withdrew the challenge. There are procedurally reasons for that, strategically reasons for that. But it's an example of a very real risk of a court coming in and sort of pulling the rug out from under the arbitrators while the arbitrators had already proceeded to the merits phase of the case. And the third part of the life of the arbitration is the end, and once the award is rendered. And after that award is rendered, there are 2 kinds of proceedings before the courts that will often take place. The first set is the losing party will often commence annulment proceedings to vacate the award, and that will usually be or should be at the seat of the arbitration. And those annulment proceedings, the criteria for vacating an award will vary from jurisdiction to jurisdiction. It could be deferential, or it could involve reviewing the underlying merits of the case. It will really vary on where you're bringing the annulment proceedings. On the enforcement side, you could actually, the winning party will tend to commence one or more enforcement proceedings in jurisdictions where they suspect that the other party has assets that they could seize. And usually in countries that are members of that are signatories to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the courts still retain some discretion to refuse to enforce an award if certain grounds are met. They're Article 5 grounds, and so, some of them are narrow, some of them are broad. For example, there's a public policy ground that a court can rely on to justify refusing enforcement. So in fact, at the end of the day, the national courts kind of hold the fate of an arbitral award, of an international arbitral award in their hands, both in terms of vacating the award in annulment proceedings and enforcing the award in enforcement proceedings. So given that context, it's actually kind of remarkable that the ICSID system of arbitration has managed to exclude all of that judicial involvement until more or less the time of the execution against the award. But before getting into sort of the key features of the ICSID system that allow it to do it, the question is, what is ICSID? And ICSID was established by the 1965 Washington Convention that was executed in Washington and sponsored by the World Bank. And it was intended initially to create a framework for the protection of international investment by trying to depoliticize investment disputes and taking them out of the national courts and creating a sort of a neutral forum where those disputes could be addressed. And it's more of a procedural mechanism that's been created. And what it does is it allows a non-state entity to sue directly a state entity without any issues of sovereign immunity coming into play. There are today, I think, about 147 states that are signatories to the ICSID Convention. So it's been ascribed to by a lot of different countries, and although procedurally, if you look at the rules, the arbitration rules of the ICSID institution, they're very similar to some of the other ones, the LCIA, the ICC, and they cover the same kinds of topics, procedural topics. But what's unique about ICSID in comparison to these other arbitral institutions is that it has insulated itself from the involvement of the national courts. So how has it done that? How does it actually offer a privatized system of dispute resolution? And it does that in several ways, but there are three aspects that I'd like to focus on. First, the center oversees the appointment and the challenge of arbitrators to the tribunal. So there's no opportunity to go to the courts for that. When parties can't agree, ICSID will appoint from a list of panel of arbitrators, and the challenge to one arbitrator is heard by the other two arbitrators, and if they can't agree, it goes to the chairman of the administrative council of ICSID to make that decision, but then the buck stops there. There's no resort to the national courts. ICSID has the last word. Second, it does this, there's Article 53 of the ICSID Convention provides that final ICSID awards are not subject to any appeal or any other remedy except those provided in the ICSID Convention, namely rectification, interpretation, revision, and annulment. So what does this mean? Among other things, it means that the national courts have no ability to review ICSID awards whatsoever. Any challenge to an ICSID award has to be heard by another three-member ICSID panel that's known as an ad hoc annulment committee. And third, and finally, ICSID awards are final and binding such that the contracting states have agreed to comply voluntarily with these awards. And in the event those states do not comply voluntarily, all of the other contracting states are required to treat that ICSID award as if it were a final judgment of their own courts, subject, with a caveat, subject to their own laws on sovereign immunity against execution, from execution, sorry. So the enforcement regime of ICSID imposes an obligation on all contracting states. On the losing state, it imposes an obligation to comply with the award, And on all the other contracting states, it imposes an obligation to enforce the award as if it were a final judgment of the local courts. And in contrast, if you look at the other arbitral regimes, like the ICC and the LSA that I've already mentioned, enforcement of awards is going to be subject to local laws and or if it's in a country that's a signatory to the New York Convention, to those Article 5 grounds that I mentioned earlier, including public policy. So there is some discretion in terms of, there's some level of review maybe, and there may be some discretion in terms of whether to actually enforce the award. So the advantage of ICSID is that it provides this enhanced enforcement regime, and it produces an award that national courts cannot vacate, and that they must recognize and enforce as if it were a final judgment of their own courts. So, I mean, by way of conclusion, what I would say is that it's been pretty remarkable to see how ICSID has really flourished and been able to insulate its disputes from the national courts. And I think the reason that it's been successful is because the states, the states themselves got together and decided that in the context of investment disputes, and in the hope of creating a neutral forum that would attract more investments, they agreed that they would curtail the rights of their national courts. They would curtail their right to have their national courts play a role in investment disputes. That said, the system has in recent years come under some attack, and partly it kind of goes to some of the points that Dean Shapiro raised this morning in terms of our values of legitimacy and accountability and human rights. And there's also concerns with environmental rights. And the reason for that is because ICSID deals with investment disputes, and these investment disputes tend to be the kind of public interest sectors like oil concession contracts, et cetera. There are other interests at stake. And it has come under some attack as to whether the system is working properly and whether private arbitrators should be deciding these kinds of public interest type disputes. So it's almost come full circle, because initially that was the reason why they even instituted the ICSID system, but now there's some commentary out there that questions whether or not that's the right approach. So, thank you.
When you were using the football analogy and the problem of bribing a referee, I'm currently mediating a case involving the Chickasaw and Choctaw Indians suing the governor of Oklahoma over water rights on tributaries of the Red River. And the Choctaws had a historic way of resolving disputes. It was called stickball. It was really lacrosse. But the ball had to hit a stick rather than going into a net. And the way they solved the problem of the referees, they didn't have any referees. There were no rules. So sometimes there are other ways to solve that particular kind of problem. Thank you very much for inviting me. I've enjoyed meeting members of the Thrower family and for giving me the opportunity to unveil an idea I've been mulling over for quite some period of time, but haven't really had the opportunity to share with other folks. This is a very limited idea that actually comes to ADR from a slightly different direction. It's a dissatisfaction with ADR, not in comparison to public justice. I serve as a special master, probably done it about 80 times, and so I've kind of devoted my life to improving the system of public justice. And it seems to me that there are some distinct problems now that we find with alternative dispute resolution that we need to address. I guess the first case I did was in the latter part of the 70s. I'm really old. I've been doing this for a long time. And what we've seen over the last 30 to 40 years, we've seen how lawyers have kind of co-opted both arbitration and mediation and made it look more and more like litigation. It's becoming more and more expensive as time goes on. Well, I'm going to need some help here from the There we go. That mediation, in effect, has become just another tool in the toolbox of litigators that add to the expense and the time of litigation. And arbitration, international or domestic, looks more and more like litigation in terms of the cost and expense. And so what we need really is kind of a new look, a new way of trying to see if we can resolve disputes a little bit better than football or stickball, or like the Japanese used to do. They would hire sumo wrestlers. Each side would hire a sumo wrestler, and they would actually charge money for people to come and see the match, and that paid for the neutral referee in the process. And so I'm building on Clayton Christensen, who's a professor at the Harvard Business School. His theory of innovation is that someone comes up with a new idea and people buy into it. And then the entity or entities that have that new idea, let's just take the PC, for example, will make it better and more expensive, better and more expensive, better and more expensive, better and more expensive. And then someone will come in with something that is not quite as good, but cheaper and more convenient, that will replace that original product. And the cell phone, of course, is a good example of that kind of innovation that we find in products. The second point is that for those of you 30 and below, you tend to communicate differently from the way I still read the New York Times in paper. I'm addicted to reading newspapers. My 34-year-old son communicates by email. My 29-year-old daughter communicates by text. You communicate in what we could call a transmedia kind of fashion. It's not just multimedia, but it's an interactive. For those of you who are my age, you go to the movies, and at the beginning of the movie, you say, the movie's coming on, shut down your Blackberries or your iPads, no tweeting, no texting whatsoever during the movie. Well, transmedia is texting and tweeting during the movie. It's using clips of YouTube at the same time that you've got the ESPN little underlining. The transmedia is sort of an interactive way of using multiple modes of media. And that's the way folks tend to communicate. I don't think the younger folks are really wired differently, but I think the way in which you receive information is very, very different from the way in which those of my generation receive information. So the idea here is, how can we create some type of dispute resolution mechanism? And the reason I'm suggesting arbitration is because I don't think the federal courts or the state courts are quite ready for this yet, but you can do almost anything you want in arbitration as long as the parties agree. So I'll pitch this to the general counsel of Google and the general counsel of Facebook. If you have a dispute, this is a way that you can resolve the dispute. And the idea is to see if we can utilize these new modes of communication to create a cheaper, more efficient kind of dispute resolution process. Because our mode of trying cases really hasn't changed for centuries. And as a result, it's become, I think, somewhat ossified, or as Christensen said, it's gotten better and better and better and more expensive and more expensive and more expensive, so that the vanishing trial is indeed a vanishing trial. We just don't use trials anymore. When I first started practicing law with Vincent and Elkins in Houston, defending General Motors, they would give me $10,000 cases and I'd go down and try them. You just don't see that happening. The business model of law firms has really changed rather radically. So the concept is to see if we can marry these newer methods of communication to have a cheaper, more convenient and effective presentation of evidence to resolve disputes that are consistent with due process. And fundamentally, the idea is that litigation typically, a trial is typically storytelling time. It's a narrative. And how can we allow each side to have their narrative, but integrate the narratives in such a way that it's consistent with due process? And so the idea is the following. You create a multimedia narrative on the plaintiff side, and this is mainly for corporations at this point, although it might evolve beyond that. You create a plaintiff's narrative, you create a defendant's narrative, and you do it in a multimedia form, a movie as it were. Then you share those two presentations, and using a standardized computerized platform, you integrate the two presentations. And so instead of sequential stories or direct and then cross-examination that's kind of jumbled around that makes it very difficult for a jury or arbitrators to understand really what each side is trying to say, that you integrate the two and you give an opportunity periodically for the other side to create a counter-narrative. One of the problems of the narrative form of trying cases is that in our minds, memory and imagination tend to be located in the same place. And so oftentimes what will happen is someone will create a narrative, and there might be some weak points in that narrative, but we'll jump over them with our imagination to come up with a consistent story, and we believe the plaintiff's story or we believe the defendant's story. The idea here is to provide some opportunities for some analytic input during the story, during the narrative presentation, to show the weaknesses, so each side can show the weaknesses of each side's story. And then you can add tweets and Twitters and emails and text along the way, so that it is truly an interactive, that all the parties are participating, whether it be the arbitrators or the parties, can have this multiple platform. And then if you wanted to have an oral presentation, because lawyers like to do that, you can go ahead and do that as well. So the general concept here is the current strategy in most litigation is very similar to the prisoner's dilemma. It's a massive retaliation. I'll impose more costs on you than you can impose on me, and at the end of the day, you're going to have to settle the case, you're going to have to cave, because this is the battle of resources. And so the idea is to come back to what was essentially the way in which we originally resolved disputes, on the merits, with creativity on the part of lawyers, rather than just imposing costs from one side to the other. And one would hope that if you put a limitation on the amount of time that each video, multimedia presentation could be, if you put a limit on the amount of time that the integration would involve, if you put a limit on the amount of time rebuttals could be, and if you allow the creativity of lawyers full bent, that you would be able to create a combined narrative that would give, and as I said, I'm doing it in the context of arbitrators because you can probably get away with it with arbitrators if you had folks agree. You have this combined story that would make it easier, using more modern modes of communication, for someone to understand which way would be the best way to resolve a dispute. And at the same time, you can make it much more convenient, and you could make it cheaper by being able to do everything long distance rather than having to have people travel to a particular spot. Now, I've got a little film clip of probably the state of the art right now of the way people are using multimedia that I'll show you just a couple of minutes. And then for those of you who are below 30, you qualify. Imagine, okay, that this isn't just a lawyer who's part of a multimedia presentation, but there's also the kind of interaction that you would use. I'm teaching a course at Duke this semester on legal strategy, and having the students actually do this. How you would integrate this into sort of the next level of communication.
When a corporation makes a dangerous product and somebody gets hurt because that corporation failed to warn about the dangers, that company is responsible to whoever they injure. My name is Lisa Blue, and I'd like for you to meet my client, Carol Ernst. This is a story of Carol and Bob Ernst. Carol, because she met her love partner late in life, and some of us are lucky enough to meet our soulmate early. Carol knew Bob for 4 years and was deeply in love. And what Carol decided to do was wait until her oldest daughter was out of school. They married and were deeply in love. And during the time they were married, and because of Bob's untimely death at the age of 59, they only were able to spend 11 months together before Bob met his untimely death, partly because of taking a dangerous drug by the name of Vioxx. Carol and Bob were active together. They decided when they got married they wanted to do everything together. They exercised together. And when Carol said, well, I really can't do some of the things because Bob, who died from this drug that he took, Bob was a marathon runner. But when Carol couldn't do the kinds of things that Bob did, they rollerbladed together. Carol would watch as Bob crossed the line of some of these strenuous marathons. They went to fairs together. They did ballooning, hot ballooning together. They crossed the nation in an RV. And their marriage, you'll hear from Carol, was the most significant event of her life, to marry her soulmate. Well, together for 11 months, and then Bob died. Bob died as he went to sleep that night, and you're going to find out one of the causes, and I believe the judge will tell you this. Vioxx doesn't have to be the actual only cause of Bob's death, but Vioxx clearly was one of the significant causes that caused Bob to have a heart attack. So, members of the jury, this is like CSI Angleton. And I know from your jury...
So that gives you, it goes on and on. This is based on a trial in Brazoria County that Mark Lanier tried against Merck against Vioxx. But you see what's being done now is the lawyer is becoming part of the movie. The lawyer is on the screen with the backdrop. And then you can imagine adding other multimedia kinds of approaches to this, so that you could actually have a much more effective form of communication, and you would be able to have what I would hope would be, over time, lawyers doing what lawyers do best, rather than the prisoner's dilemma of massive retaliation. Lawyers could use their creativity to try to sell their perspective on precisely what happened. Transmedia arbitration. Thank you.
We have a small amount of time available for questions. The first question I get to ask is quite simply, during that presentation by the lawyer in this multimedia situation, would the other side be able to simply shout during a presentation, baloney?
Yeah, absolutely. Only
okay.
You wouldn't shout it. You would tweet it.
It would be.
You would tweet it.
It would be the underlying, the role underneath the film.
Ask the kids. I mean, the way they communicate today. I mean, it's a combination. They send films, they send YouTubes, they send texts, they send tweets.
Yeah, the problem is they do it during my classes.
That's right, and they're saying baloney. That's right.
And
Yeah,
it's probably better than your class.
Yeah, Lord knows that's true. Okay, well, if there are panelists that would like to ask questions, I want to start there, and then we'll see if there are some from the audience that would like to participate. Would either of you like to go at any of the others?
Let me ask about Concepcion. I'm on the executive committee of the board of the American Arbitration Association, and I made the following argument that Concepcion saved arbitration in the consumer context in the following way: that if industry were to be faced with class action arbitration, and probably multiple class action arbitration, because there could be one in Florida, could be one in Ohio, sort of the Class Action Fairness Act kinds of problems, that industry probably would have ceased including arbitration as a mode of dispute resolution, which would have left individuals to the court system. And so the argument would be that Concepcion really saved arbitration in the consumer context. Is that right, wrong, indifferent?
I think that's right. Saved it, gave it a shot in the arm, and the question is, does a statute that passed in 1925 about commercial arbitration between business entities, does it belong in the contract of adhesion? Well, you really are talking about individual rights here, and there was no bargaining over it and the like. But I think that's right. I think the Supreme Court is so fulsome in its embrace of arbitration agreements that they're all good. It's okay. And the court really sees very little, it seems to me, special about court litigation. It is always talking about how it's just another way to do it, and these are wholly interchangeable, fungible ways to do it. And of course, it gets into all those other problems as well. But I think that's right. I think what we're going to see now is when you go home and look at the contracts of adhesion to which you were a party, they're going to have arbitration clauses and class action waivers, and the whole thing's enforceable, I think.
One could also make an argument that the United States Supreme Court, and Chief Judge Kaczynski can correct me if I'm wrong on this, doesn't seem to like class actions a whole lot. I remember in the Walmart case, I think the dissent that Chief Judge Kaczynski had said the only thing in common, some of you may remember the Dukes case, the women who were suing Walmart. So the only thing in common that the plaintiffs have is the fact that they're women and they work for Walmart. But I see the U.S. Supreme Court not favoring class actions in very many, certainly not personal injury context.
Well, that's a criticism of the class, not of class actions. And I would see a distinction between those. I mean, in the appropriate class out there, people that do share some kind of injury, it seems to me it makes perfect sense. But if you've got a class that's only loosely connected, then that's something different. That's why I would respond to that rather.
Well, the surprising part of that case, it seemed to me, was the part that gets inside baseball, but the 23A2 part about there's no common question. Not that they don't predominate; it's just not there. I think everybody was on board on that this was not a proper B2. You can't get damages in an injunction case. But it just remains to see how this shakes out with cases down the road, because now if commonality is tougher to get. Yeah, I think it is. I think it's a serious.
Well, let me take that. I'm a special master in the BP case, and we've got a property damage class action. What do you think the Fifth Circuit's going to do with that? Because you have fishermen, you have hotel owners, you have strip clubs, you have dentists, you have beer distributors, you have farmers, yet it's all, and then there are no subclasses. It's just all one class. What do you think about the vitality of that in the Fifth Circuit?
And the claim is the same. The
claim comes out of the same oil spill, but they were affected differently by the oil.
Sounds a little bit, but they were affected by one event, as opposed to in Walmart you had active discrimination after active discrimination in different places, different grades, and so forth. So
I find that interesting as well, simply because if you have a class that has different kinds of claimants in it, you also have the problem of legal ethics. That is, you've got lawyers with conflicts of interest among various members of the class. That usually busts a class up. pretty easily by itself, where you have lawyers that can't be fully independent with regard to all these different people with different kinds of claims. That goes to the nature of the poorness of the class designation, it seems to me.
The other,
Subclasses of the strip clubs, it seems to me.
yeah, and you'll take care of that one. The other thing that was interesting about that was under OPA, the Oil Pollution Act of 1990, there was the creation of something called the Gulf Coast Claims Facility, which Ken Feinberg, I mean, talk about ADR. Yeah. Ken Feinberg was the czar of giving away BP money for these varieties of folks. Is that kind of a model in a mass tort context where a defendant steps forward to try to resolve the cases earlier before they go to litigation, because the argument he was making was that you don't have to pay the attorney's fees, I can pay you money sooner, your transaction costs are going to be lower. Is that kind of a model going forward, do you think?
Yeah, I do. I think what we're seeing also is, instead of class actions, a lot of cases now get MDL. So you have multi-district, you put them in one court, and we see a global settlement. And global settlement, even outside the class action, what you're trying to do, it's a bill of peace for the defendant. The defendant's in favor of this. The defendant says, look, I'm going to pay the piper anyway. Let's just do it once and buy everybody off. And that, it seems to me, is what Feinberg was doing. And there's no law there. It's just all what you can agree to. One quick point about the class action viability at the Supreme Court. The one case that cuts the other way, it seems to me, is Shady Grove, which was a great Erie case. And Shady Grove upholds, not only did Rule 23 apply, but Rule 23 is valid. And it seemed to me, to a degree, the court got class actions fat out of the fire, at least to a degree on that. So it was a little bit on the other side of the ledger. I'd like to ask Colleen one quick question. Are there any other efforts to get internet? I thought that ICSIT idea is fantastic, because you get the countries to agree that our courts aren't going to intermeddle with this, we're just going to enforce these. Are there other areas outside investment disputes where that's being tried? Or?
No, I haven't come across it. And like I said, I think ICSIT has in the past 10 years, its caseload has really dramatically increased. And so there have been a lot of awards that have been rendered against states, and states are beginning to push back. And Argentina, I think last week, withdrew from ICSIT. Because it has a lot of ICSIT awards against it with which it has not complied, and there's a lot of pressure there. So, and it's not the first. I think it's maybe the third that's withdrawn. So I think there's some growing pains attached with ICSIT right now, and we're not quite sure where it will settle. But no, I haven't seen any other institutions that have followed the lead.
But just to follow up on that slightly, have you ever been involved in any of the dispute resolution mechanisms out of places like Dubai that have created special economic zones within themselves so that Islamic law will not apply, and you go into these spaces within Dubai, and international law of commerce will apply instead, and they have their own dispute resolution mechanisms within those zones, and I didn't know if that was any part of your experience at all. But that seems to be one of those wonderful examples of your notion of neutrality, of trying to take it out of the Islamic courts, because they would never have that kind of commercial activity if local courts were in fact in charge. Okay. Maybe one question. I don't know. The people from the Law Journal are going crazy. Yes.
Well, I guess I was thinking about the California experience on Concepcion, that it seems to me that some level, a state that creates the law has the right to say this is a way to enforce it is through civil litigation or the class mechanism or what have you. It seems to me we have to keep the public dispute resolution mechanism vibrant, because we need law. I mean, even if we're going to have ADR on everything else, all settlements and all resolution of disputes is done in the shadow of the law. And when you have 70–80% of your courts of appeal opinions being non-precedential, you know, where is that? Where is the law, as an old song say? Oh, that's where's the love? Anyway, so, but it seems to me the state, you know, I see it as a federalism, the state should have the right to determine that. It'd be handier, I think, if it were from the legislature. And in fact, I think that would be nicer, because then you can say there's democratic buy-in to this. But some claims are not. Case law is where we get contract and tort and property and everything else. And so I don't know why the voice couldn't be that side of it. I hear your argument on the democratic side, but you know, think about that.
Well, I think for purposes of staying on time, I will call the panel to a close here. I thank my panelists very much for their presentations. I found them fascinating, with the exception of Professor Freer's. But other than that, they were really pretty interesting. I appreciate your participation, and thanks once again to the Thrower family and to the Law Journal for running this thing. And we will quit and allow the break to take place.